Please do take your seats. I will now invite Mona Rishmawi, who is a very old friend of mine and Chief of the Rule of Law Division of the Office of High Commissioner for Human Rights, to share with us her perspective on the influence and impact of the ICTY jurisprudence on customary law in the work of the UN Human Rights Center. And I would like to use this occasion, since I mentioned the center, to acknowledge the presence here of Judge Nevi Pillay, the High Commissioner. Mona?
Thank you very much. Thank you, Judge Meron, and thank you. It's a big honor and pleasure to be here. I must say it's very difficult to be on this panel without Nino Cassese, who was supposed to be on this panel with us and actually confirmed to his presence. His premature departure has left a huge vacuum that I think we felt it already through the way he was mentioned here, that it will be very difficult to fill. I frankly was very much looking forward not only to hearing him, but also teasing him, because in a number of things that I will mention, I will say about human rights law and customs are inspired by him. Nino and I worked together on the Commission of Inquiry on Darfur. He was the president, and I was the executive secretary of that, or the executive director of that commission, and we developed long friendship before and after the commission. This commission was one opportunity that Nino, as he liked to be called and we like to call him, used to shape the minds and approach of international law and lawyers. And as I say, some of what I will say today is inspired by him. The impact of the work of the ICTY on international law, particularly customary international human rights law and criminal law, has been already discussed a lot. Today, now I will focus on human rights law. I will talk about two dimensions. I will talk first about the correlation between ICTY and human rights law in a legal sense. And then I will try to show some operational nexus between OHCHR and ICTY. Human rights law has developed a lot since the conflict in the Balkans. Today, much of human rights law is codified in treaties. All countries in the world are party to these treaties. They have ratified one or more, actually an average of 2 to 3 treaties per country are ratified, human rights treaties are ratified per country. The implementation of human rights obligations are discussed very regularly in open fora through the participation of members of the international community, states, NGOs, and so on, in situations such as the treaty bodies and so on. But the most important thing, in a process called Universal Periodic Review, which takes place in the context of the work of the Human Rights Council. So it's an open discussion about the implementation of human rights law in Geneva. Yet, I think there is a lot to be said about coloration and the issue of customs. I would like to mention here 3 issues that I think are quite important. Judge Meron wrote about the convergence of international human rights and humanitarian law, as you called it, being humanized by human rights law. And you noted that there are multiple ways in which human rights law has shaped the provisions of international humanitarian law. This process has been clearly visible in the jurisprudence of the ICTY, where chambers have looked at international human rights law to assist them in crystallizing the humanitarian law norms. I would like to mention particularly 2 issues here. Unlawful confinement is the first one, and then I will go into genocide. With regard to unlawful confinement, the chambers at ICTY have contributed significantly to the elaboration of the legal regime applicable to internment of protected persons during conflict, particularly through filling some of the protection gaps that existed through the incorporation of human rights law into the humanitarian law framework. Together with its establishment of clear standards for detention of persons, generally the ICTY has assisted in strengthening the resolve as well as the legal protection against unlawful forms of detention. Two dimensions of detention are important: treatment of detainees and lawfulness of the detention itself. On the treatment, we heard this morning several times the mention of the ICTY jurisprudence with regard to the definition of torture and how ICTY dropped the requirement of a public official or other persons acting in public capacity from the definition of torture. This was a very important contribution that was carried through during the drafting of the Rome Statute, and this phrase was actually also, which exists in the Torture Convention, was also dropped from the ICC statute in the definition of torture. Very important ICTY contribution in this regard. If I may respectfully say, however, ICTY is yet to address head-on the important diversion of rules between human rights and IHL with regard to the legality of detention, legality of confinement and imprisonment during armed conflict. With regard to the crime of unlawful confinement, the trial and appeals chambers have limited themselves to restricted provisions in the Geneva Convention. Although here although there has been greater acknowledgement of the important contribution of human rights law in relation to imprisonment as a crime against humanity. Human rights law provides rich source of norms and principles that would serve to bolster the protection of those placed in confinement or custody. Under human rights law, Article 9 of ICCPR, arbitrary arrest or detention is prohibited. The same article establishes the minimum procedural safeguards that must be according to all detainees, including the right of everyone who is deprived of his liberty by arrest or detention to take proceedings before the court in order that that court may decide without delay on the lawfulness of the detention. In other words, Article 9.4 establishes a right of judicial review of detention. This right of judicial review has been particularly contested in the last few years, particularly in the context of the Guantanamo detainees and the arrest of other individuals in the so-called war on terror. While the review of requirement is required in the Geneva Convention in the context of international armed conflict, only the bare minimum is provided. Such a basic system is open to abuse, and there is multiple instances of such an abuse. Moreover, in internal armed conflict, Additional Protocol 2 is completely silent on the question of review. There is no obligation on the detaining power to instigate any formal administrative or judicial oversight of the detention. In light of the fact that there is no clear obligation to release detainees and the end of hostilities, this places detainees in an illegal vacuum. I saw firsthand the impact of this only recently when I visited Libya only about a few weeks ago. There are thousands of detainees that are being held in makeshift prisons, in makeshift detention centers, already subjected in some instances to torture and other forms of ill treatment, and without any effective resource to legal processes or to legal remedies. The application of human rights law, particularly the prohibition of arbitrary detention And a simple system of screening would have elevated a lot of the difficulties that we saw recently in Libya. Human rights law in such a situation it provides an important legal remedy and protection against abuse. There is now some thinking about looking at a convention on detention, and that could be one of the gaps, this correlation between human rights and IHL, that this gap can look into it. I would like now to turn, just for brevity's sake, to another area that I think is very important to touch on, is the ICTY contribution in the context of genocide. OHCHR has to, in many times, my office, the Office of the High Commissioner, who's present here, has to look at whether, in particular cases, particular criminal acts of certain gravity may amount to genocide or crimes against humanity. Here, the jurisprudence of the tribunals, we had to do that several times. The last one was in the context of DRC, in the situation in the DRC. Here, the jurisprudence of international tribunals has become extremely important to how we look at these questions. But maybe I should start with the important case of ICTR and Akayasu, which was decided in 1998 by ICTR, as I said, and was the first case in which an international tribunal was called upon to interpret and apply the definition of the crime of genocide. The panel of judges, which included our own High Commissioner Navi Pillay, when she was with the ICTR, considered the meaning of ethnic group and also the important judgment of rape and sexual violence as a contributing to genocide. There is also the important media case on incitement. The ICTY built on this case law, and in Henckaerts, with regard to the Srebrenica massacre, in this case familiar to many, the court considered what contributed an element of part of national or ethnic or religious group. This particularly part of the population definition is extremely helpful in practical sense when we look at the application of the Genocide Convention. I would like now to move into what I call the operationalization of human rights law. And I would like to mention 5 areas in which basically ICTY and OHCHR work in practice has actually overlapped, and how OHCHR has been enriched by the work of the tribunals in general. First, let me say that 2 out of the 5 high commissioners that we had already come from the tribunals. The influence of the tribunal is also clear in the method of work that we have, and our 2 institutions have complementary mandates of combating impunity, undertaking fact-finding, although in different ways, and establishing facts with regard to events, enhancing accountability, and supporting victims. Let me start with the first issue that I want to talk about, which is the importance of a pattern. Cooperation with ICTY from our side and other, and together with substantive applicable law established by the Tribunal, led OHCHR to be much more aware of the importance of establishing a pattern of the violation. The High Commissioner for Human Rights, as well as country and thematic special rapporteurs, issue public reports seeking to establish the facts with regard to specific violations. These reports have become an important source of information for the tribunals. First ICTY and later the ICC. Fact-finding is undertaken in many forms, including through the mandate of the High Commissioner, the special rapporteurs, the treaty bodies, and so on. OHCHR staff, on occasion, special rapporteurs sometimes, have called cooperated with the tribunals when the request was made to us. And the High Commissioner has always been systematically cooperative with this and allowing the sharing of documents that OHCHR has gathered with the tribunals. We have witnesses who actually testified before the tribunals. In all instances, contextual information and information that has enabled the finding of a pattern of the violation has been provided to the tribunals. Often our staff has been used as background purposes. Also important are commissions of inquiry and fact-finding missions. These are increasingly used tools by the Security Council, the General Assembly, the Human Rights Council, the Secretary General, and the High Commissioner to respond to threats to international peace and security and to promote and protect human rights and ensure accountability for serious violations of human rights on IHL. OHCHR to date has supported more than 30 commissions of inquiry and investigative bodies. In fact, OHCHR role goes back to the Commission of Experts on former Yugoslavia in 1993, which we actually supported, as well as the one on Rwanda in 1994. Right now, we are supporting 5 commissions working, this year, not right now, this year we supported 5 such bodies, including working on situations such as Sri Lanka, Cote d'Ivoire, Libya, Syria, and Yemen. A common mandate of these commissions is to examine human rights and IHL violations that are taking place. A question typically asked is whether such violations constitute a pattern of violations and which indicate the gravity and threshold for the international crimes that have been met. Determining a pattern of violation is also important in assessing whether or not not only state responsibility but also individual responsibility have been established. Recently, the International Commission of Inquiry on Libya and the fact-finding mission in Syria uncovered patterns of human rights violations which led them to conclude that there have been widespread and systematic attacks against the civilian population, that consequently crimes against humanity may have been committed. This has led to the calls for the referrals of the 2 situations to certainly of Syria to the International Criminal Court, and in the case of Libya there was a simultaneous processes between the Security Council and the Human Rights Council in terms of fact-finding and referral to the ICC. Time? Okay, sorry. I would like to mention 2 important issues, and I'll stop at that. The other issue that I want to mention is identifying perpetrators. This is not uncommon for commissions of inquiry to ask to identify perpetrators. Here, there has been a lot of, I would like to mention 3 issues with regard to the commissions of inquiry and how they actually worked on identifying perpetrators. The first one regards the standard of proof. Here, the commissions of inquiry rely a lot on the jurisprudence of the tribunals to look at the standards of proof. In the famous Darfur Commission, Nino Kasese actually wrote that the Commission could not comply with the standards normally adopted by criminal courts or that used by international prosecutors and judges for the purpose of confirming the indictment, and adapted the standard of proof to the needs of a specific commission of inquiry, which became the standards that we use in all other commission of inquiries that mentioned. The second one is the method of identifying perpetrators, and the third is naming perpetrators, but I will not mention those for now. There is also a lot of work on witness protection. I'm going very quickly because I want to go to my last point, which I think is very important to mention, is the issue of reparations. Historically, the focus on the fight against impunity has been focused on trying perpetrators. This has not been balanced with the effort to restore the victim's sense of dignity. The right of remedy and reparations to victims have become firmly enshrined in elaborate corpus of international human rights and humanitarian law. The GA in 1926 adopted some guidelines in this regard. It is clear that the ICTY is aware of this framework. In its report to in his report to the Security Council and his latest to the General Assembly delivered on 11th November, actually President Robinson called for a reparation fund to be established for the victims, acknowledging that failure to address the issue of compensation constitutes a serious failing in the administration of justice of victims. We very, very much welcome this, and we think this is extremely important. I would have liked to elaborate a bit more on this issue, but I just want to stop here and thank you very much for your attention.
Thank you very much, Mona. This was extremely interesting, and I'm glad that you raised a number of issues on which we have not really focused this morning. With regard to detention, if I may also add as a little commercial for the Tribunal, treatment of POWs. In the Vukovar case, I think we had the first ever judicial determination with regard to authoritative interpretations of the third POW Geneva Conventions, where we confirmed the rule, which already appears in the third Geneva Conventions, that if an army takes custody of POWs, they may not pass custody of those POWs except to an entity which is capable of properly exercising protection and giving protection to those POWs. And this was a very, very important normative ruling which was not made before by judicial institutions. And the second point, which I found very interesting in your comments, Mona, was the role of the ad hoc tribunals with regard to human rights protections. Actually, in one of the post-war issues of the British Yearbook of International Law, a scholar by the name of Joyce Guttridge, who also worked in the Foreign Ministry in London, wrote an article about the history of the Geneva Conventions and analyzed in that context Common Article 3 of the Geneva Conventions and asked, is this does Common Article 3 not really state some very fundamental principles of human rights? Of course, we in the Tribunal apply humanitarian law, but if we take Common Article 3 or the various rules stated in crimes, in the provisions on crimes against humanity, we see that there is a very considerable substantial overlap between things normally portrayed or presented as humanitarian law and their human rights content. And this applies to Common Article 3, to, of course, crimes against humanity. For example, the prohibition of persecution. How to distinguish between that really, except in the apart from the context, between those prohibitions in humanitarian law and in human rights. And then with regard to gender, of course, there is a tremendous overlap between prohibition of rape in humanitarian and in human rights law. And finally, when it comes to the provisions on fairness and due process, I don't believe there has been a part, of course, from the European Court of Human Rights and the American Court of Human Rights, there has been any tribunal which devoted so much attention to elaborating and giving proper foundation to due process and fairness, and that again is not only a provision of humanitarian law clearly stated in the protocols and the Geneva Conventions, but also it is a fundamental rule of human rights. Now, I will turn we have very little time, but I will turn the microphone to the audience. We have room for a few questions. And we have some microphones in the back, so whoever would like to speak, please raise your hand, and you will immediately have a microphone. Please.
Thank you. My name is Van der Wild, University of Amsterdam. I would like to ask to the whole panel, what makes the ICTY and the ICR so special? What is the greater authority of their decisions for the establishment of international criminal law when compared to national courts? I would like to shortly elucidate my remark. As we all know, the complementarity principle will trigger lots of decisions by national courts, and in the near future, they will inevitably contribute to the development of international criminal law. Do you foresee a very productive cross-fertilization between international criminal tribunals and national courts? What is your opinion on this issue?
James, would you like to say something about the authority that we have in terms of stating the law in comparison to national courts? This is really something on which you have so much authority, and I would like George to fill in on that.
Well, authority in this field is not generic, it's specific. It's specific to institutions and has to be earned by them, and that's true of national courts as well as international courts. National courts are obviously at a considerable disadvantage in terms of stating what international law is because of their own situational and constitutional constraints, which means that it's all the more remarkable when they do it, as has happened recently, I think, with the House of Lords in a number of cases. As to the ICTY, well, you heard what I said, and I'll leave it to you to interpret it. The Tribunal has contributed very substantially to the development of international law, and once you've done that, you can turn around and say, well, that's the way it always was. But it's obviously not true. It's obviously, there's a historical process going on which is necessary because of the situation the Tribunal is in, and we can only appreciate what they've done in the light of its ultimate wisdom or lack of wisdom. It's one of the peculiarities of international law that although there are bodies which, for example, the International Court, where there is inherent authority, but the court has been in business for 90 years, or the best part of it. For most tribunals and for all individuals, authority is very hard won and possibly more easily lost than it is won.
George, would you like to add something to the legitimacy, reasons for the legitimacy and credibility of the ICTY?
I wouldn't say the ICTY as such, but in general, first of all, let me say that the national judge is more the natural judge in criminal law because he is much closer to the facts, etc. But the national judge acts under national law, and unless we have a perfect match between international law and national law, that what is criminalized in both is reflected faithfully on the national level and is administered unbiased, with no bias and so forth, we may not need international tribunals. But unfortunately, if we speak of what we are speaking about here and in the recent future, we are speaking of situations where national courts are ineffective for different reasons, whether because the state is a failed state, or because of bias, or because of very strong feelings, etc. So, if we are looking at international crimes, obviously international tribunals have greater significance because, as James has just said, what a national judge does, you don't know, is he really speaking of an international crime? Most of international crimes constitute regular crimes in every country, plus an element which makes them international. And in order to find this plus, etc., international courts and tribunals are directly more implicated, more habilitated to explain it. Moreover, they are reachable. Why? When we speak of a national judge, well, James has mentioned the House of Lords and etc., but for the large majority of national judges, what they do is not known to the rest of the world. And so in every way that I mentioned, international tribunals have greater significance than national tribunals as far as international crimes. We are speaking of international criminal law. Thank you.
Thank you very much, George. If I could add a word to what my distinguished colleagues said. First, I think that I could not agree more with a comment made by James a moment ago. International courts, like national courts, have to earn the trust and the confidence of the international community of governments and scholars and jurists. And we were greatly helped by the fact that the very first seminal judgment, which was so important for our subsequent history, the Tajik case, was produced by a very, very impressive panel of judges. This does not go without saying, and it is something on which we all have to work very hard and to do our very best to produce judgments which are not only fair, but well-based in the law, and are expressed in a way that will be persuasive to jurists and to colleagues. But I would like to add to the discussion one other element, the importance and the greater added value of international judicial precedents. Take again the Tajik judgment. Now, the Tajik judgment pronounces something which at that time was not necessarily accepted. Applicability of most norms of humanitarian law, previously perhaps considered as applicable mostly to international armed conflicts, is applicable also to internal armed conflicts. Now, the fascinating thing about that interlocutory appeal of 1995, I believe, was that how quickly its authority proved to be accepted by governments. And by governments who just a few years earlier, in 1977, voted down in Geneva, in the context of the second additional protocol, attempts to incorporate those rules in the sort of diplomatic legislative plane. And we see that, and this is something which is very helpful to the development of norms of international law, humanitarian law and human rights, that precedents and decisions of international courts are very quickly adopted by the international community at large. And this is something which, again, adds to this problem of legitimacy of the tribunal and its credibility. You had a question, you need a microphone.
Thank you. Rishmawi, Syria, Lancaster University, United Kingdom. I have written a book on the Srebrenica tragedy and currently writing another book on the ICTY and its effectiveness. I would like to address this question to the new president, Professor Judge Meron. It's what was said by the first president, the late Antonio Cassese. He said that justice leads to national reconciliation, hopefully in the West Balkans. According to my research, some of the victims, or many of the victims, haven't had adequate compensation or restitution. I know the retiring judge, Patrick Robinson, has been lobbying very hard to get a trust fund, suitably financed trust fund, so that adequate compensation may be meted out. Do you think this UN trust fund is likely to come about? Thank you.
Thank you very much. Let me make it very clear that I think not only I, but all the judges of the tribunal are extremely grateful to Judge Robinson for courageously and without hesitation pushing forward and promoting this initiative for a fund for compensation along the lines of what is has been established for the ICC and so on. States have been supportive of his efforts on the rhetorical plane, and there have been some positive developments in the sense that I believe the International Migration Organization is now doing a feasibility study, but this is not an easy concept to realize at times of grave economic crisis. But I think that if something is right, we should push for that, even if it takes time to accomplish. We will take one more question.
Hello, I'm Dr. Sanya Bahul from the University of Essex and Director of the University of Essex Transitional Justice Network. Now this question is actually a close follow-up on the previous one, but I mean it in particular to Mona Rishmawi. You mentioned the importance of reparations and restoration of dignity to victims. Now there are many more modi of doing that other than just establishing a restoration fund. And I wonder what would be your advice to the ICTY as to what it could possibly do for the remainder of its mandate in terms of reparations. So what would be the steps forward in addition to this lobbying for this fund that is, as Judge Meron just mentioned, very difficult to lobby for in the current climate. So that's your question.
Mona?
Well, first, I think we should acknowledge that the first step has been made, and I think it's a very significant step that I think President Robinson has actually put on the table. Putting on the table the initiative, the way he put it in the General Assembly and the Security Council actually is extremely important I think member states now know exactly what needs to be done. As you mentioned correctly, the concept of reparation actually is multifaceted. It also includes not only monetary compensation, it also includes things like memorials, apology, restitution, and rehabilitation in the sense also of psychological and physical issues. So it's a very multifaceted notion that I think can be explored in in all its forms. I think what the IOM is doing is, as a feasibility study, is a first step, but also I think much more can be done in the region with regard to particularly, monuments, documentation centers, and so on. So I think we can look at it in the role of the tribunal, but also what can be done in the respective countries and what can victim groups and states can do to enhance the right of victims to reparation on this regard. Thank you.
Thank you, Mona. We will take just one more question. I understand. The person is waiting with a microphone. Christian, who is? Yes, please.
Je vais poser deux questions qui en fait se recoupent. Madame Mona a parlé de l'incidence des travaux du tribunal pénal international pour la Yougoslavie sur le développement des droits de l'homme. Et monsieur le juge Meron a juste effleuré la question. J'aimerais savoir en quoi le tribunal pénal international pour la Yougoslavie a véritablement contribué au développement des droits de l'homme, entendu ici, disons par rapport à la personne qui est poursuivie devant le tribunal. Et la question subséquente, c'est...
Just one question. Okay, please proceed.
C'est dans quelle mesure une juridiction internationale comme le tribunal pénal international pour la Yougoslavie peut appliquer le droit du pays dont est ressortissant la personne poursuivie. C'est quand même le droit qui est censé être reconnu par cette personne. Je vous remercie.
I believe that we have answered the question of the contribution of the Tribunal to Human Rights. I just spoke about our application of Common Article 3, of our application of the various prohibitions listed as crimes against humanity, of our constant jurisprudence on human rights and due process and fairness. However, we define these in the abstract, there is no question that these are virtual statements of content of very fundamental principles of human rights.
May I say something?
Please, of course.
Yeah. I think two things to keep in mind. I think there is, of course, very important and very significant contribution to the formulation of legal standards. We saw this recently in the way, and I actually wanted to talk about that a bit, but for time I didn't, how disappearances was considered in the context of the formulation of the Convention of Disappearances, how the crime of disappearances, enforced disappearances, was actually looked at in the human rights context. So I think the formulation of the legal principles are very important in terms of how the tribunals look at the practical application on them. But in my view, perhaps the most important aspect in terms of human rights work is really in the methods of investigation. I think this is really significant because the tribunals brought with them a lot of very important issues about witness protection, about how to deal, although there is no victim found, but how to deal with victims, about how to name perpetrators in a very responsible way. So because people, of course, have the presumption of innocence, have the right to due process, have a lot of issues to be considered at once. So for me, what the tribunals have been doing, and particularly with our work, is really adding this important dimension to actually operationalizing what I call the fight on impunity. So it's not just an empty fight, it has elements, and these elements are important to take on. And we in the office take it very seriously, and we work very closely with the colleagues in all the tribunals, the 3 of them that are operating, also with Sierra Leone, ICC, ICTR, ICTY, Sierra Leone, those who have human rights mandates, and it's very, very useful and very enriching.
Thank you, Jean-Marie.
Thank you. No, I just wanted to come back to the question on the national courts, because I think we should nevertheless underline the importance of national courts, and the complementarity principle means that in fact what we see coming through research is now actually a wave of national case law. So it was mentioned that before national judges were ineffective and there wasn't national case law on humanitarian law, so the international judge stepped in. But right now with the legislation that's on the books and the courts that have picked up on this, there is actually going to be a wave of national case law. And I want to underline also that this national case law in the theory of custom law is actually state practice, because state practice comprises the practice of the executive, the legislative, and the judiciary, whereas international case law is not state practice. International case law gains its value, as has been mentioned, as persuasive evidence that custom exists, and by the precedential value and the precedents that it sets, that can then influence the development of practice. But so I think the importance of national case law will be growing, and we have to, of course, keep looking at it and collect it and assess it as a contribution also to state practice and the development of humanitarian law. Thank you.
Thank you. Before giving the floor to George, let me just add one comment on this question of national laws. Of course, we are a tribunal applying international law. We are a tribunal applying international humanitarian law in all its aspects. We are not applying in general national law of this or that country, perhaps with a certain proviso here. With regard to sentencing, we are directed by the statute to take into account the sentencing practices in the former Yugoslavia. But one thing which we have in our work constantly to bear in mind is something which pertains to comparative criminal law, or general principles of justice and criminal law, because this is part and parcel of the normative universe in which we operate. And this we have to take, and we do take into account. George.
I just want to mention one small example of how international justice has energized national justice. The first time, the obligation under the Geneva Conventions of 49, which is now accepted by all countries of the world. First time, the obligation to prosecute or extradite was officially mentioned in a judgment of a court, of a national court, came after the creation of, in Denmark, I think, after the creation of the ICTY. So the fact that the ICTY came, etc., awakened the dormant obligation which everybody in the world had accepted as a state, and that shows the dialectics between national and international justice in this field. Thank you.
I know we could have gone on with this discussion for a long time, but I am instructed by our masters that our time is up. So I would like to thank very, very warmly to my co-panelists for their brilliant performance and their great contributions. And I thank you for your attention and presence here. And the meeting is adjourned.
Ladies, please, if
Can I have your attention for Judge Robinson, or I think someone wants to say something?
Do I have the mic?
Yes, you do. Oh.
It's working now, President.
Mr. Chairman, I was trying to get your attention to say something. I have a principle that if my name is mentioned 3 times, I should intervene. And it is in relation to to what I've been advocating in the United Nations and elsewhere for the establishment of a system for assistance to the victims of the Yugoslav conflict. I haven't even called it reparations, although I believe as a matter of law, reparations are definitely due. You know? But I know reparations is something of a bad word in the United Nations system. So I have been calling for a system of assistance. I'm being very pragmatic about it. In the ICC, they have in their statute a trust fund established. The victims of the Yugoslav conflict are no less worthy of assistance than the victims of the conflicts that give rise to trials in the ICC. And so I want to use this occasion to appeal to everyone here, in particular the states that are represented by their ambassadors, to support the idea, which I believe is now taking root, because the IOM has been assisting us and been giving us very, very practical and very good advice. What they said to us was, you need first to know what the needs of the victims are. Don't assume that you know. So it's a bottoms-up project. And they have raised the funds, $38,000, to do this appraisal. And that is the very first step. So we are on the road. And I appeal to everyone here to give it their resounding support. Thank you.
That was indeed an important thing.
And again, congratulations for taking up this extremely important cause.
Thank you very much. That was indeed an important thing to say. Perhaps also something to mention with regard to President Robinson. I think one of you said that he was retiring. Nothing is less true. He's not retiring. He's outgoing for the presidency, but he will still be a judge at the ICTY. That being said, the time has come for a very much welcome lunch break, I'm sure. We understand that some wanted to ask additional questions, but the speakers, I'm sure, will make themselves available over lunchtime to discuss in a more personal manner with you. And only one last thing to say is bon appétit and be back on time. This is going to be at 2:20. Thank you very much.